Good morning, Ms. Mellon.
SJC-10160, Commonwealth versus Rodriguez and Marshall.
Mr. Nixon, good morning.
Good morning. My name is Kevin Nixon. I represent Lionel Rodriguez. The issue I want to start with is a SORS violation. Now, it's undisputed that Mr. Rodriguez is a Hispanic person who sought individual voir dire in large part because he was concerned about being tried by an all-white jury. It's undisputed, too, that Ms. Ortiz was the sole Hispanic juror on the Venari, and it's undisputed that the jury that was sat on this case was all white and non-Hispanic.
Is it also undisputed that she did not fill out the questionnaire accurately?
Well,
that she did not report her...
There's two parts to that. One is that her son, a juvenile, had, I think it's fair to infer from the record, after she mailed the questionnaire, had been caught stealing, was the way she put it, had pled guilty, and had entered the court system that way. And as you can see from the record, Your Honor, she's glad about that. She thought that was a very good thing. The other issue that came up when she was taken to sidebar and asked individually, as were all of the potential jurors, about her involvement in the criminal justice system was her own involvement. And she acknowledged that without any hesitation. Neither one of those reasons was advanced by the prosecutor as his reason for striking her. It was because she had checked the wrong box on the questionnaire.
Well, that is the reason, though, right? I mean, she checked none when
that's the reason. That's the reason that was offered. Yes. Now, the prosecutor offered that the first time when he challenged her for cause. The judge made findings as to why he was not accepting that as a challenge for cause, and the prosecutor thinks that because he repeated that, the Commonwealth now thinks, or at least argues, that because the prosecutor repeated that as his reason for exercising a peremptory, this court should accept it as genuine and adequate. Now, the problem with that is that there are no findings made anywhere on this record at trial about whether the prosecutor's offered reason was genuine and adequate. Now, for this court on appeal to somehow divine from a written record that the prosecutor's reasons were adequate and genuine is impossible. A finding of genuineness is the same as a finding of credibility or sincerity. And there's no way that you can do that with what this prosecutor said any more than you could conclude that a witness who testified at trial...
Isn't that implicit? That the judge found the explanation acceptable?
Why, because he accepted it? If that were the case, then the court would never reverse on SORA's grounds. Every time an appellant's here, he's arguing that the judge erred by accepting the prosecutor's proffered reasons. And the court then looks at the record and asks itself if first, did the judge make the requisite findings of adequate and genuine? In this case, you have to say no. And then the court asks, well, is there any way that we can draw those findings from this record? And it suggests there isn't.
Well, do you concede that an apparent false statement on a sworn form is adequate as a reason to remove a juror?
Not in light of the judge's findings that it was not false.
The judge is allowed to determine that it's not a basis for a cause, but that's a different standard than determining whether or not it's appropriate for a prosecutor who may view the matter differently to decide that it's worthy of a peremptory, isn't it?
Well, the judge actually went farther than that. He didn't just say that isn't sufficient basis for me to remove her for cause. He actually found that there was nothing, I can't remember exactly what he said, but bear with me. He said that she did not engage in any deception, that she was not responsible for making this error, that she simply made an error and recognized it as she was sitting in the courtroom listening to the judge's questions for the jury generally. And that as soon as she was in a position to disclose those things, she did it without hesitation. He found on the record no deception, sincerity, no effort to hide, and readiness to disclose these things as soon as the questions were put to her.
But what about the inability to just follow the obvious instruction that's called for in the question?
Well, I think you can see in reading the Q&A between the court and this potential juror that she has no difficulty following instructions.
No, not as to that point, but as to the legitimacy of a prosecutor's peremptory challenge. This person just can't, answer a simple question put to her in writing.
Well, when she acknowledged that she made a mistake by checking the wrong box, yes, Your Honor.
Yeah, but that's the point. She she made a mistake. She made a mistake that perhaps she just can't follow simple instructions, and a prosecutor doesn't want that kind of a person on the jury.
Well, I think that inference is more than canceled by her readiness to answer the questions when it's put to her orally, and she explains why she got it wrong before. It's not like she's hiding anything. She does, and I think
It's not a question of hiding. It's a question of competence.
I understand your point, Your Honor, and I think that the inference that she's incapable of answering this question accurately is more than negated by what happens at sidebar when the questions are put to her orally.
But that's assuming that the prosecutor has to see it exactly as the judge does. As Justice Gant says, it's a different question whether you're excusing for cause and whether you are exercising a peremptory. And so the prosecutor can make, it was a he, right, his own
Yes.
judgment about what that means to him. I mean, we don't have any other indication. There's nothing, I know this is so, there's no other person who came up who had not filled that out right that he kept on the jury, is there? I mean, I'm not saying that's a sine qua non, but I think it's hard to just assume that. I mean, it seems to me that the core of your argument is that because the judge found what he did when the for cause came up, that is somehow binding on the prosecutor and would preclude using that reason as a matter of law almost for a peremptory challenge, and I just don't think that that's correct.
Well, actually, the core of my argument is that the judge's failure to make the requisite findings of adequacy and genuineness leave this court in a position where it can't substitute on this record its findings of adequacy and genuineness for the absence of any findings like that on the record. Actually, the evidence that was elicited at sidebar during the questioning indicated that Ms. Ortiz was a juror that a prosecutor ordinarily would want to keep. She approves wholeheartedly of her son's prosecution. She says at sidebar, I've always felt if you do the crime, you got to be ready to do the time. The other thing that she mentions is that she herself was a victim of a violent crime in Boston, and then followed up with testimony and was glad to see her assailant sentenced to 7 years.
If I could turn your attention to a different issue, and that
Yes.
is the admission of the photographs to the testimony of the ME.
Yes.
Was there anybody during the course of trial who said that these photographs were fair and accurate representations of the body of the victim?
No. No one testified.
So there's nothing in the testimony to indicate that these are indeed authentic and fair and accurate reflections of what the body looked like.
No one testified to that, Your Honor. There was no effort made in any way to verify the photographs.
Was there a photograph of the victim as a live person?
No.
There was my memory is that the ME who did testify, was it Dr. Flumenbaum in this case?
Yes.
That he was asked, do these photographs look like they're fair and accurate as far as you can tell from the autopsy? I mean, I'm not suggesting that that's the same as fair and accurate since he wasn't there, but that was how they came in. That is how they came in.
Maybe my recollection on that point is in error, but I don't remember that. My memory is that they simply went in and over objection were admitted in evidence. And then what happened next, of course, was what I'll call the Nardi error of permitting the second doctor who hadn't conducted the autopsy to testify as to the findings of the first doctor who had, but wasn't available for cross-examination.
If we agree with you on the first point, does that mean that, I mean, who else could have testified that they were fair and accurate? A member of the victim's family?
There's usually a police officer there during the autopsy.
Would it be acceptable if a member of the victim's family did that?
Well, I don't think a victim's family is usually admitted into the autopsy.
I don't know.
No, I think that would be very unusual. But there's usually a police officer there. There are other people there during the autopsy. Now, you know, the admission of these hearsay.
You could videotape it as well.
It's videotaped as well. Yes.
Well, it is videotaped?
Well, often. I don't know whether it was in this
What-
case.
the-
There was no evidence of that offer.
No
or
videotape and
admitted.
evidence here.
And of course, that prejudiced the defendant because, as the prosecutor argued when he was seeking these photographs admission, this medical testimony was a big part of his case of extreme atrocity or extreme cruelty, the enhancing predicate for this first-degree murder conviction. And I see I'm out of time.
I
No,
had
that's- it's okay.
one question. The diagrams.
Yes.
Now, they came in without objection. Are you, but you're, I mean, it's a different standard, but you say that is also error?
Yes, that's clearly hearsay as well. It's a written document, a hearsay document being offered for its truth. And I'll answer any
Mr.
questions.
I actually do.
Yes.
Again, on the admission of the photographs, the Commonwealth says the defendant died from blunt force trauma, and that he died from that was not in dispute. Okay?
Yes.
So let's assume that it was not in dispute, but you've got an objection to the photographs, correct?
Yes.
So how do we deal with that claim
Well,
of the Commonwealth?
I tried to explain it in the brief.
Right.
It's not cause of death that was really at issue here. And that's not the enhancing predicate that results in this first-degree murder conviction being returned instead of a second degree. It's the cruelty that's depicted in those photographs. And that was the prosecutor's argument in seeking their admission. So it's not cause of death. I don't dispute that the cause of death played no role in what I'm concerned about in making this argument. It's the number of blows that are recorded in the autopsy findings, the types of blows, the depiction of the blows and injuries that are in the photographs, and all these things are, of course, repeated in the diagrams. All of that hearsay evidence went to this enhancing predicate of extreme atrocity or extreme cruelty that produced this first-degree verdict.
How was it, in a course of trial, was it established that the deceased person was who he was alleged to be? I mean, usually a family member gets up and sometimes they introduce a photograph of the person. And
Well, a lot of the witnesses were his friends, the people who had been drinking with him that night. I think the first witness may have been actually, I'm not really sure. I haven't looked at that part of the brief in a while. I don't want to misstate what happened. I know this wasn't really an issue because even the defendant's mother testified, and she was a friend of actually Mr. Marshall's mother testified, and she was a friend of the decedent, Mr. Carpenter. So the identity of the decedent wasn't never really contested or put in play, directly by someone testifying, I know that man, and that's the way often a trial would start with the decedent's mother or wife or something like that.
So, Mr. Nixon, you would disagree with the Commonwealth that if we look at the question of prejudice, and this is the Commonwealth's position, it's that issue is limited to whether the defendant was prejudiced by the admission of the photograph without proper foundation, not whether the photograph itself is inflammatory. You're saying...
No, I don't think there's, as far as inflammatory, I don't think I've included the photographs in the record appendix.
I saw that,
They're
yeah.
black and white because of the
reproduction.
problems in my office, actually. But,
so what's the harm in this case?
That's what I'm trying to get at.
well, as what? On
mean, what do you-
on
But
this
you've just
issue,
said they're not inflammatory, so...
Well, no, but they're not inflammatory, as I understand that term to be used by this court and other appellate
Sure.
courts when you're
When
considering.
we said the photograph
they're
shouldn't have
not
come in.
gruesome. They're not.
You're not challenging the identity, that he wasn't the person who was the...
No. What the prejudice of admitting the photographs and all this other hearsay evidence on this medical issue was that it tended to support graphically and with hearsay the Commonwealth's position that this wasn't just a murder, but it was a first-degree murder by reason of extreme atrocity or extreme cruelty. And you can see in the record.
But wasn't there other very compelling evidence from the witnesses themselves? Weren't the photographs just cumulative of the witnesses' testimony?
There was evidence that he was, kicked to death, basically, and there was evidence, too, that he was severely injured. But that doesn't, first it didn't cause the prosecutor not to want this evidence and to fight for it at sidebar when it was challenged. And second, it There's no reason to conclude it didn't play an important role in the jury's decision-making process. They have the evidence there. They've been asked to conclude that this isn't just a second-degree murder, but an extremely cruel murder or extremely atrocious murder, and they've got photographs and hearsay evidence helping them make that decision.
Thank you, Mr. Nixon.
Thank you.
Mr. Fallon?
Good morning, Your Honors. Richard J. Fallon for Defendant Appellant Ryan Marshall, who was convicted of accessory before the fact to first-degree murder, but who was not an accessory before the fact. Not everyone who engages in a felony together with someone else is an accessory before the fact.
And I take it, does the indictment expressly charge him with being an accessory before the fact and
Says
having
before
committed
the-
no other crime?
Yes, it says before the crime was committed. And in fact, my reply brief is wrong in that I didn't point that. I sort of said it just had A. It says, the indictment in fact says, before the crime was committed. He in fact, obviously I have it.
Well,
I have it here.
well,
On A9.
factually, Mr. Marshall was engaged in some kind of argument with Mr. Carpenter
Sure.
shortly before
Right.
the fight
exactly,
out in the
exactly.
street.
Right, outside the back door.
They had heated
the
words
apartment.
or something
Exactly.
like that. Is that the theory, that he then knew what was going to happen out in the
Well,
street?
that's one of the reasons of the prejudice of even if you don't overturn on insufficiency of evidence, which of course is substantial risk. McGovern and many other cases say that's substantial risk of miscarriage of justice itself. But even if you don't overturn on that, that precisely is part of the prejudice of this kind of what I've called the rogue indictment. Because there's no evidence at all that argument, that he knew anything or that he directed anything or that he consulted. There was the argument. And as I pointed out, in a recent motion, opposition to a motion to reduce verdict, the Commonwealth claimed that argument was providing a motion, made him guilty, provided a motive, made him guilty, made him more guilty than somebody providing a weapon. Now, of course, the jury didn't hear that. But my point is, if the DA's office could be so misled by this indictment of somebody as an accessory before the fact, who clearly isn't an accessory before the fact. I mean, if somebody comes upon an attack and joins in, if that's an accessory before the fact, it's meaningless. And the definition in the statute and in Demore has always been counseling, hiring, or otherwise procuring. So that's precisely the prejudice of this sort of twisting thing. Because not only...
Was there evidence that he did procure the...
No, zero. Zero evidence. That argument, arguments don't provide guilt.
Well, what role did Mr. Tirado, if I'm saying his name right, was he there when Mr. Marshall and Mr. Carpenter were arguing? Didn't he break it up?
No, he didn't break it up, but the evidence was he was there. And then Tirado goes and Carpenter goes, and then out in the street, when Marshall's not even still in the apartment, apparently, Tirado attacks Carpenter, or Carpenter, they have words, whatever, when Carpenter's fixing his wheel, I think what happened, Tirado cut the tree. And then Tirado makes some calls to his friends, and then Tirado starts beating Mr. Carpenter. And that's when Miss Rose, who's the witness at trial, and Mr. Marshall together come upon the scene as Tirado's beating. But there's nothing before...
There's no suggestion that Marshall and Tirado...
No suggestion at all. No evidence, not even a suggestion. And in fact, you could see the Commonwealth, the prosecutor understood that something was wrong here because defense counsel kept objection. It's not accessory before the fact. And at the end, in his closing, he said, oh, it must mean before completed. The crime was completed, is what the prosecutor said. Because he knew there was something wrong. And of course, that can't be the definition. It's not only not the definition. Everybody acts before a crime is completed, or they wouldn't be part of the crime.
Do you think the statute sort of has, one can read it as having kind of disjunctive parts, but
Right.
adding up to the same thing. That is, you can be guilty as the principal. That is, whoever aids.
Exactly.
Or is an accessory before the fact by counseling, procuring, hiring.
Principal felon, that's the key point. Yeah,
Okay,
right,
but
not just
here's,
principal.
here's my question for you. If the indictment had said that Ryan Marshall did aid or before the felony incite, procure, counsel, hire, you would have no argument, would you?
You're, on that one, I wouldn't. You're right, because Aiden, he obviously he should have been tried for murder like everybody else. He was, you know, the evidence showed Commonwealth. Surely there was enough evidence to convict him of an aider and abettor, no question at all.
Was there evidence presented to the grand jury that he was an aider, that he was an accessory before the fact?
I don't believe so, Your Honor, because there's no. I'm sorry, I don't know because I.
Well, how did this indictment come out the way it did?
Well, Your Honor, I've argued very strongly, and I think we know, because if you go to the fact, Mr. Torres, if you know, there's 5 people involved.
Yes.
Mr. Torres is the guy who held the coat. The only people who were indicted for accessory before the fact were Mr. Torres and Mr. Marshall, who kicked him in the leg twice. Who are the people who are most likely to get lesser included?
But everybody, I mean, except, I wonder, did Mr. Marshall did he get the manslaughter instruction at the trial?
Mr. Marshall got none because it was a lesser
Okay,
included.
but everybody else did, right?
Except for Mr. Torres, because he was also indicted for accessory before because they wanted to kick out. I mean, it's very clear. I mean, sort of we're grown-ups. They wanted, for the people who they thought they might get lessers, they wanted to kick out the lessers. So they indicted Mr. Marshall for something he wasn't guilty of.
You don't have any evidence of that, though, do you? I mean, you're supposing that.
It's common sense. I think it's an overwhelming inference, Your Honor. That's what I would argue. And the Commonwealth has not suggested any other reason for indicting them for, and I think appropriately
The
so.
Commonwealth suggests that's what the grand jury came up with, because I think, at least this is what I read, that the grand jury came up with that because, in fact, the conduct of those two was less directly involved in the blows that caused the death.
But the indictment was before the crime was committed. I mean, yeah. I mean,
No, the indictment wasn't before the
No,
crime was committed.
Well, the indictment says before the crime was committed.
Oh, you mean
I'm
it
sorry.
reads that? I'm
Yeah,
sorry. I thought
doesn't
you meant
read
it was
lesser.
issued
Right,
before.
I'm sorry. I apologize.
Yeah.
That's
Okay.
what the indictment said. But, Your Honor, I mean, the Commonwealth's argument here is, well, I want to go to prejudice because I think, I mean, my first argument is clearly that insufficient evidence, that's of itself, you overturn, that's substantial risk. You don't need prejudice for that. And I'll mention briefly, I know I don't
That's
have a
not
lot.
just overturn. That's, if it's insufficient evidence, that's acquittal, isn't it?
It's acquittal of accessory before the fact, Your Honor, no, of that crime, clearly. Now, you know, I don't have to deal with whether that's, and I explicitly did not discuss the issue of whether it's double jeopardy for murder.
Well, so what was the theory here of the Commonwealth? I mean, were they trying to say that Marshall and Torres kind of set the stage and juiced the others up?
Oh, you're going to have to ask them. There's no evidence.
Well, what did they say at trial? What was the?
Well, at trial, as I said, the
Prosecutor knew he had a problem.
in the closing came up with a whole new definition that doesn't make any sense of accessory before the fact.
And the judge did not instruct on accessory before the fact?
Well, that's the thing, Your Honor. The instructions, at one point the judge says, you know, accessory means before the crime is committed. But then when he went to the elements, he just said aided.
It's really a joint venture instruction.
Yeah, oh, sure, exactly, Your Honor.
Well, you say you don't want to talk about double jeopardy, but I'm just curious. If we were to agree with you, let's say you persuade us.
Yes, sir.
Can the Commonwealth turn around and charge him again with murder?
Well, Your Honor, I'll say this, and I surely don't. I mean, I'm not going to argue against my client's interest, and I'm not going to foreclose what another trial attorney might do. I've read, I guess it's D'Stasio, where basically it says, because there are variants, a guilt as accessory before the fact would constitute a variance upon an indictment as a principle. Therefore, an acquittal upon indictment as principle is not a bar to a prosecutor as accessory before the fact. But so, I mean, you know, that's what
That's the other way around.
Yeah, I know, it's the other way around, and you're exactly right, Your Honor. But I don't want to argue that.
I want to make
because
sure,
I don't wanna
Mr.
foreclose-
Fallon, that you don't say anything here that will bind your client. That issue is not before us, correct?
That's exactly what I said. That issue of double jeopardy is not before you. That's exactly my point.
It's not before us, but do you argue that, and I can't remember, do do you argue that we should, if we accept your argument, that we should direct that a dismissal of the indictment happen? Yes, you do, right?
Well, that indictment, surely.
Yeah, but you're just saying you're not making any argument about what happens hereafter.
Right.
Okay, I got it.
And by indictment, you mean that part of Section 2, which speaks of before the act, not the aiding and abetting part of 274, Section 2.
Right. It says
So they
aid or accessory before the fact.
Right. Now, if I could turn very briefly to the extreme atrocity or cruelty.
Right.
The jury asked a question
Sure.
which said, how come it's the same?
Right.
Was the instruction the same with regard to first and second
here's
degree?
the funny thing, because I got so confused, I called up the DA yesterday, and then I called back and said, never mind. Because, the instruction, that's part of the instructions basically say, it's the same for first to second degree. But as my argument points out that I finally figured out because I was confused, and I went back and said, but it is the same. That's part of the problem. The rule is the same because the instruction for Mr. Marshall was completely derivative. And that's actually, I'm glad you brought that up, because it was completely, if somebody else gets extreme crossing, he gets it as long as he's secondary, as long as he has malice aforethought. And Rodriguez got the instruction, well, I just want to make two very quick things. Rodriguez got the instruction, it's your indifferent, if Rodriguez is indifferent or takes pleasure, that's the Canadian factor. Mr. Marshall could have been convicted on the basis of Rodriguez's mental state, because he was saying if somebody else is extreme atrocity, So those instructions, however bizarre they are, and reading them, that it's exactly the same for first and second degree murder, were right for extreme atrocity. Not, of course, for deliberate premeditation, but he wasn't convicted of deliberate premeditation.
And I guess what seems to be a part of what you're arguing is that if he'd been actually charged as a joint venture, he would have gotten an instruction which would have spoken of his state of mind.
You sure should have, exact. And one final thing, just the extreme atrocity argument of Mr. Nixon, of course, saying that these photographs might have added to that, and the extra evidence might have been applies to Mr. Marshall too, because again, he was completely the instructions were completely derivative. And I guess I'm over time, so if you don't have any more questions, I'll sit down.
Thank you,
you
Mr.
very
Fallon.
much.
Good morning, Ms. Eisenhower.
Good morning. May it please the Court, Rachel Eisenhower for the Commonwealth. Turning first to the SOARS violation, I don't believe that a prima facie case of discrimination has been made out, and I know that there are cases saying that a challenge to a single juror can satisfy that prima facie showing, and certainly everything that happened in those cases happened here, but what happened additionally here is that there had been a challenge for cause. Now, I have not seen any of the previous cases where that challenge follows a challenge for cause. So I believe that that should undercut the second prong of the prima facie challenge. However, that is a novel issue, so I don't know that it is.
Well, it's
No, you go ahead.
at very least, I suppose, one could argue that the Commonwealth had some basis other than the racial composition of the jury to mount a claim
I agree.
that jury shouldn't be in. I'm trying to think of the case, and forgive me, I'm not good on names, which was the social worker. It was out in the western part of the case. Do you know the one I'm meaning?
Benoit?
Was that, it was either Burnett or Benoit. Was it Burnett?
No, the social worker wasn't Benoit.
Was she not challenged for cause
It's
first?
possible. I didn't review that one.
I think she might have been, because I think there was a claim. I think it didn't. I think the death was.
It's possible that's true. The
excuse me.
three cases I looked at this morning were Fryer, Harris, and Maldonado. Those are the three that did not have a challenge for cause first. So it's possible I missed one in my survey.
We can check that, but I think your point is, notwithstanding that, even if it's not the first case, it's a slightly different context. That when there's no challenge for cause, and then just when you go to exercise the peremptories,
Exactly.
when everybody recognizes that there's no basis for cause, you've just got some other reason. Okay.
I agree, Your Honor.
Could I, assume for the minute that it gets over the prima facie
Yes.
part. What, you don't discuss Benoit in your, I mean, you don't cite it in your brief, so you don't discuss it. What, if you get over the prima facie part, what is different in this case than that case with respect to the articulation of reasons and the judge's findings?
Well, the judge did not make
Implicit findings, I mean.
The judge did not make findings that it was adequate or genuine in this case. The phrasing he uses when he turns to the prosecutor is a little different. He doesn't say, well, now I'll hear from the Commonwealth. He says, you know, do you want to put anything on the record, I believe is his phrase. So finally parsing it, those are slightly different things. However, I think the big difference is what you can read from the because you do after, even assuming that the judge's findings are inadequate, then the appellate court has the opportunity to look and see whether they can see from the record that the prosecutor's challenge was valid and accurate. Now, if we were to finally parse the prosecutor's words like statute, grammatically the only thing he references is the fact that the box is not checked. But then he says, the box is not checked, and what we learned after that is she had this and this. Now, I think it's clear that he intended to incorporate the juvenile status of her son, but if you're parsing it grammatically, the only thing he actually says is the box. So I would defer to the court on how you want to read that. Next, the autopsy photos. ADA Stearns pointed out to me this morning that that circumstantial authentication exists in Massachusetts, and that occasionally a photograph can be authenticated just by where you find it. For instance, oh, I found it in the dresser, therefore it belonged to this person. But there isn't actually any circumstantial authentication in this case either. There was really no attempt to authenticate it at all. So unless
I think there was this. I don't think it quite meets what was necessary, but there was this effort to ask Dr. Flummenbaum, do these look like autopsy photos? Something like that.
Yeah.
And he said yes.
Yeah, there's a sort of a passing reference to, so you've got some photos there, sort of thing. Probably doesn't rise to the level of authentication. Probably not authentication over an objection.
So then what do you do?
So then we have to ask whether that could possibly have influenced the jury's verdict. Now, Mr. Rodriguez was primarily trying an identity case. So his primary defense is that Rebecca Rose didn't know who she was talking about, that she was a very drunk 100-pound young lady, and that she didn't know what she was looking at, and that it was a dark street. And so that was.
We are looking at a preserved error standard.
We are. So.
Did anybody testify to the use of the tire iron on Mr. Carpenter?
Yes, I believe they did.
So there was testimony that somebody saw him being hit with a tire
Rebecca
iron.
Rose said that she saw someone hit him in the head with a tire iron. The other evidence I would look to for extreme atrocity and cruelty for that factor, that the reason that I've argued that the photo was cumulative of other evidence, is I would point particularly to the testimony of Ivan Brody, the paramedic, who describes seeing the multiple bruises on his head, sees the shirt cut off, sees the multiple bruises on his body. And of course there is Ms. Rose's testimony as to the tire iron. There's testimony of several of the victim's friends who mostly fled the scene very quickly when the attack started, but one describes seeing, I believe it was Kevin Rose saw the rear view mirror, him being on the ground, being kicked by a bunch of people. So there was other testimony as to the attack.
So Eisenhower, this issue obviously comes up a lot. Are these videotaped autopsies?
This was the first time I had ever heard of such a thing. I don't know that they're videotaped. I will look into that.
It may make sense. I'm just thinking because this substitute medical examiner is not unique to this case, certainly.
No, it seems to have been coming up a lot lately. But I will look into that when I get back into the office. I don't know that a tape exists in this case. I haven't seen any reference to it either in the transcript or in any of the other objects I've looked through.
You finished?
Yes.
There was an objection here to the introduction of the photographs, correct?
Yes.
So the prosecutor knew that there was some reason that somebody might have a problem with it, right? The objection was on the basis of authentication?
I think the record indicates the trial prosecutor completely misunderstood the objection because he made no further attempt to authenticate them. Rather, he argued relevance. So I think that he just heard what he expected to hear. He heard
Okay,
objection to
okay.
photos. He assumed
That it was relevance.
that it was relevance, that it was going to be the normal autopsy photos, very grotesque. It's a very standard objection. So I think he just heard what he expected to hear. And
Okay.
I assume the judge did too because he just accepted the prosecutor's explanation. I don't know why they didn't seem to notice that it was a different objection or why the defense counsel, though it certainly wasn't his burden at that point. But
So you're saying that if we look at the record, this is not a preserved error?
no, I'm saying it is. Absolutely.
She's saying it is, but my question, which I think you correctly anticipated, was if he knew it was an objection on the basis of authentication, and even if the judge had overruled the objection, the prosecutor would then go do a whole bunch of other things. Even if he
Exactly.
couldn't authenticate the photograph, he would make sure, it was a he, right?
It
would
was a
make-
he.
He
It
would
was a
make
he.
sure that there was other evidence of extreme, he wouldn't have relied on it, but I can understand, now I understand in a sense where his head was, that you expect it to be on the basis of gruesomeness. When that's overruled, which it often is, then the prosecutor says, well, that's in, so I'm free to use them, and then uses them. And that's the problem here for us, because when you've got the prejudicial standard, it's not as if the photographs then disappeared and you had
No.
powerful evidence coming in.
So if we review the record and discover that they indeed were prejudicial, consequence is either a new trial or reduction to the second degree, correct?
Yes.
And which do you want?
Let me step in here too. We often give you the choice, so you don't have to make the choice now. I don't mean to put. You can
You
answer
would-
Justice Gantz's question if you feel that you're in a position to do so.
It would not be my choice to make in the office hierarchy. So if our office were put in that position, I would have to ask, my elders and betters. So
Or
You're-
maybe your
you-
betters, if not your elders. I didn't mean to interrupt
No,
you,
no,
Justice
that's fair
Gantz.
enough.
You meant the opposite.
Yes, I did. I heard the opposite. I heard relevance. But in fact, that's what we have done. Assuming that we reach that conclusion, what we have done is to say, that's up to the Commonwealth.
and again, I'm trying to be candid about the state of the
No,
record.
no, I
but-
understand. We appreciate that.
But
we really appreciate that.
I do argue they're not prejudicial. They're absolutely cumulative.
No,
all
that's
the
fine,
photos.
and we'll take a look at that.
But turning to Mr. Marshall, then, he is indicted with this indictment that says that Ryan Marshall, before the said felony was committed, did incite, procure, aid, counsel, hire, or command the said Robert Torado and Orlando Badillo and Dennis Smith and Lionel Rodriguez the said felony to do and commit. It's the prescribed language from 277, Section 79. I believe it's the only form given in 277, Section 9, to relate to 274, Section 2. So whether you were indicted under the first half or the second half of 274, Section 2, this is the form you would get. That said, going up to trial, everyone talks about this as an accessory before the fact case. At trial, everyone's talking about it as an accessory before the fact case. There's a very interesting sidebar where the prosecutor's arguing for admissibility, and he says, well, these photos are relevant to joint venture. And Mr. Atwood, the defense attorney, says, joint venture? I'm trying an accessory before the fact case. So this was certainly raised at trial. It was certainly an issue. And Commonwealth versus Ortiz in 1997 says that there are two forms of joint venture liability. There's the first, the traditional presence required joint venture liability. And then there's the second form, no presence required, that it equates with accessory before the fact. Now, the Commonwealth at trial relied on that second definition to determine that under those elements set forth in Ortiz, Ryan Marshall was an accessory before the fact.
Well,
But
what did
but
he do?
Ortiz wasn't.
What did he do? What did Mr. Marshall do?
What Mr. Marshall did was kick the victim twice. Well, physically, he kicked the victim twice while he was on the ground.
That's while he's on the ground, while the crime is
Yes,
being
yes.
committed.
And there were 5 other individuals around, 4 of whom were also kicking him, one of whom was standing holding a coat. And then Ryan...
Do you say that's before the crime was committed?
The reason in my brief I said that I was not clear that the prosecutor's statement in closing was wrong, that before the fact means before the crime was completed, is because I could find no case either way. Certainly, the plain meaning of before the crime was committed probably means either before it commences or before a substantial portion of it happens. I did look nationwide for any case defining before in terms of time. I found a vague reference to, in a trial decision that had been overturned from another state that talked about having it being before completion, and I didn't cite it because it had been overturned and it was a trial court decision from a different state. So at least one person in this universe has had that thought before.
Well, the kicking, you can't argue that it was before the crime was commenced. Can
No,
you?
no.
So then the
So
other
the other would
definition
be
is
before
substantial.
Before a substantial portion of the crime had been undertaken. And
So just so I understand, you don't argue that the argument that Mr. Marshall had with Mr. Carpenter before the act out on the street had anything to do with this?
That was not argued as part of his accessory before the fact, as part of the actus reus. I think it's relevant to malice because it demonstrates shared intent with Roger Tirado. I don't think it comprises accessory before the fact liability for the actus reus.
But is there any view of this case that he and I believe Torres was tried under the same theory? Is there any evidence that would suggest that he may have kicked the victim, that Marshall may have kicked the victim in the presence of these other people to try to get them all pumped up to do the killing?
It seems to be all of a time. I would note that in the second joint venture theory as Ortiz, which the Commonwealth is treating as fungible with accessory before the fact, based on Ortiz's language, that that before is not actually an element, and before is sort of treated dismissively by Ortiz as sort of dead letter from 274 Section 2, as perhaps akin to sort of a descriptive element of the crime, a descriptive nature of the crime, but not actually an element of the crime, sort of the way presence might not necessarily be required to be proved.
But Ortiz was not, I mean, it was a case that was argued. I mean, the whole issue was, did you need presence? I mean, it was argued as a joint venture, aider and abetter.
Yes,
case.
Ortiz is a joint venture case.
And the phrase used that when it's combining them is joint participant, which would cover both. Okay. I guess my question to you is, Ortiz treats them in this discussion about presence isn't necessary as being historically and currently together in the sense it's the same punishment, et cetera, et cetera. But the way the statute is phrased, don't you think that there are really, you have whoever aids, and you separately have whoever, is an accessory before the fact by counseling, procuring, hiring, or commanding?
Those are...
I mean, and that was what you would need to show, and I don't necessarily disagree with you about the before, but you would need to show counseling, hiring, commanding, or whatever the other word is, inciting.
Treating... It is certainly possible to look at that and from a statutory construction perspective and see these as, two separate crimes.
Well, not really two separate crimes, but two way, I mean, sort of like larceny. You've got a
Alternative
different,
theories.
yes, you have different theories of larceny, all adding up to larceny.
It seems to me that the accessory before the fact is dealing with those many situations where somebody doesn't actually, it's unusual here because he also actually participated in the, terrible beating of this person. We have other situations where this type of defendant was never at the scene, right? And so the aiding in that situation is maybe called up. You take this hypothetical where it was Marshall who telephoned. He didn't go down onto the street, but he telephoned, clearly aiding, procuring. I mean, it's in that sense.
That's certainly a fact pattern.
But I take it even under your theory, you can still be present during the commission of the crime.
Yes.
Without striking a blow and be guilty of accessory before the fact.
Exactly.
Yes.
As long as you share the requisite mental state, have knowledge, and take some sort of
Counseling, hiring, or commanding.
yes, some sort of meaningful participation.
No, I mean, but doesn't it need to be counseling, hiring? Doesn't it need to be counseling or hiring? I mean, doesn't it need to be one of those words?
I don't think it does need to be one of those words if you rely on the various.
But then it's a joint venture, isn't
Yeah.
it? You're standing by, able to lend assistance if it's required.
Well, there are two separate issues. One is that even traditional accessory before the fact liability is described by a variety of different language throughout the 20th century by this court. I think all of that has status as Massachusetts law in addition to the precise statutory text. So, for instance, my brothers cited a variety of formulations of accessory before the fact that do go beyond counseling, hiring, procuring. I believe there's Manos is one of the cases. Any of those formulations, even under a very traditional view of accessory before the fact, I think would suffice under Massachusetts law.
But the judge did not instruct on accessory before the fact.
He instructed on what Ortiz second theory joint venture, which the Commonwealth's position, Ortiz made fungible with accessory before the fact. And it's up to this court to decide whether that's an accurate reading of Ortiz.
But if he'd been charged as a joint venturer, wouldn't he have been entitled to an individual instruction on extreme atrocity and cruelty?
And manslaughter?
He would have been entitled, he might well have been entitled to an individual instruction. I don't think he was prejudiced by manslaughter because a lack of malice just results in acquittal for an accessory before the fact.
No, but I mean, as a practical matter, having it as an option makes a difference.
I defer to your experience, Judge.
Well, I mean, it's just, if a jury can choose between not guilty and finding guilty of this crime, or not guilty, manslaughter, and this crime, they're in a different position.
That is a fair point. That is a fair point. If the court has no further questions, the Commonwealth rests on its brief.
Thank you, Ms. Eisenhower.